The dispute between Ontario teachers and the government over Bill 115, the so-called Putting Students First Act, is heading to the courts. Joining us now for a walkthrough of the key issues on both sides of the legal argument, Sonia Regenbogen. She is a partner at Heenan Blakey, and Faye Faraday. She's a constitutional, labor, and human rights lawyer at Faraday Law. And it's good to have both of you here at TVO tonight. Let's go through this. We want to share some of the highlights, which you two obviously already know, with our viewers, because Bill 115, if you missed it, here's what it's all about. It sets out a 2-year restraint period and specifies a number of terms which collective agreements negotiated with the teachers must abide by, including no wage increases, the elimination of accumulating sick days, restrictions on teachers moving up the grid, and even that all agreements must conform to the Memorandum of Understanding reached with the Ontario English Catholic Teachers Association. The bill also gives new powers to the Cabinet, which can now, without going to the legislature, issue orders on what terms and conditions can be included in a collective agreement, that can impose new collective agreements, that can require the parties to negotiate a new collective agreement, and can prohibit strikes and lockouts, and can require employees pay back any that were made contrary to Bill 115. Okay, that's pretty intense. So, Faye, get us started here. The teacher unions, and we've had them on this program here, have argued that this is, in their view, an unprecedented attack on collective bargaining rights and that their core democratic rights are at stake. Help us understand why they see the bill through that prism.
The way that they're looking at the bill is looking at the freedom of association, which under the Charter protects the right to engage in collective bargaining. It protects the right to engage in collective actions to advance rights in the workplace. And they're arguing as well that it includes the right to strike. And the legislation that we have here really is unprecedented in terms of the extent of incursions on that. It has set very clear parameters for what the outcomes of any bargaining must be. If the school boards and teacher unions reach agreements that don't comply in terms that are substantially similar or substantially identical to the terms that the Catholic teachers negotiated, it gives the government the right to impose those terms on them, to nullify any terms that they consider inconsistent with that, to prohibit the right to strike, like you said, to prohibit them from engaging in interest arbitration if they choose to do that, to the extent that the arbitrator is told that they must impose those exact terms. So there's no room to move. If the parties themselves reach a freely negotiated agreement that they both agree to, the government gets a chance to review it and can tell them we don't agree.
Doesn't like it, he can
go back and negotiate it all over again. So that's not free collective bargaining.
Well, it's not. It may not be free collective bargaining, but the government obviously would argue that it's democratic and it's consistent with its powers in a democracy. Why does the union movement not see that way?
Because what's also at the core of a democracy is the right to have freedom of association. And there is not a meaningful freedom of association here. There is not meaningful access to engage in their own collective endeavors to protect their rights in the workplace. And I think we're living in a moment where we see a number of government incursions on freedom of association, federally and provincially. And those democratic rights, which are the fundamental rights, only have meaning if you have effective access to them.
Okay, hold the story there. We're going to come back and pick up on some of these themes in a second. Sonia, I'm going to oversimplify this dramatically, and then you're going to give us the legal underpinning behind it. The government, if I understand its position, essentially is saying, look, these are tough times, these are extraordinary times. We're going to do something here that isn't great, but we have the power to do it. And courts, mind your own business, because this is within our power to do. Okay, now you're going to put this in the proper language.
Certainly, thank you. Whether or not this was politically the right thing to do is something that I won't comment on, but I do want to talk about the context of the constitutional protection for collective bargaining. And what we had in a case called BC Health Services that the Supreme Court decided back in 2007 was a case that overturned decades of jurisprudence in which the Supreme Court had said the Charter doesn't protect collective bargaining. And instead, what BC Health Services found was that there is a process of collective bargaining that is protected by Section 2D of the Charter. So that's the section that protects freedom of association. But what's important is the court said at that time that it protects a process of collective bargaining.
A process of collective bargaining, meaning?
A process, meaning there's a procedural right to collective bargaining so that outcomes aren't guaranteed. And so I think that this is important to keep in mind when we think about legislation that imposes certain outcomes or limits certain outcomes, is that an outcome isn't a guaranteed, there isn't protection for a guaranteed outcome in the process of collective bargaining.
There's a guarantee for a process, but not a guarantee for an outcome.
That's right. And what we know now from the Supreme Court's decision in a more recent case called Fraser is it really rebooted the court's view of the constitutional protection that the process of collective bargaining gets. And what is now required is there's an effective impossibility standard, which basically means that if the government action makes it impossible for workers to achieve workplace goals, then that legislation may be unconstitutional. But this is quite a strict and high standard to meet.
Okay, one follow-up. The BC Health case obviously is British Columbia. The Fraser case, was that in the province of Ontario?
That came out of the province of Ontario, and it dealt with agricultural workers who were arguing that they should be given access to protection under the Labor Relations Act.
Okay, since you both referred to 2D here, and since I suspect very few of our viewers carry the Charter of Rights and Freedoms in their back pockets, let's actually show people what you're talking about here. I'm on the top of page 3 here, folks. Let's bring this up if we can. Here's Section 2 of the Charter of Rights and Freedoms. Everyone has the following fundamental freedoms. Section A, freedom of conscience and religion. Section B, freedom of thought, belief, opinion, and expression, including freedom of the press and other media of communication. I guess I should be saying subsection C here, freedom of peaceful assembly. And now here's the one that we're talking about that is operative here, D, freedom of association. Now that's all it says there, Faye. So I want to understand why unions are saying that their freedom of association rights are being violated by the government doing what they're doing. Because it doesn't, as Sonia says, there's no guarantee of outcome in that Charter of Rights and Freedoms. There's a guarantee of process and association.
And I think that Sonia and I would take slightly different takes on what that actually means in terms of scope. But what the Supreme Court held in BC Health Services is that the action of coming together as workers to form a union, maintain a union, participate in the activities of a union, to bargain collectively is protected as an action of freedom of association. The court, in fact, went further and said that the process of bargaining collectively is the most fundamental way in which freedom of association is engaged in the workplace.
So the word association, we can actually read into that union.
Association, freedom of association means the act of coming together and working collectively towards a common goal.
Including forming a labor
forming
union.
a union, but also engaging in the activities of that collectivity, which is collective bargaining, which could be the right to strike. All those actions that workers do together as collective action to advance workplace goals. That's protected under freedom of association. So it's not just a simple process. And in this case, it has to be a meaningful process in which there's a capacity to influence the outcome. And in this case, this legislation tells you what the outcome is. It tells you what you can bargain. And if you don't actually end up with that result, the government's going to impose it on you anyway. So that's not a meaningful process if they've told you this is the scope of what you can talk about and this is what your answer has to be within that scope. That's not
So that's
a
why the
process
unions
of
find
bargaining.
that unconstitutional.
That's not a meaningful process by any stretch.
So the Ontario government obviously is going to go to court and argue the opposite. What are they picking up from this argument here? Are they going to claim that actually, even though association is protected in the Charter of Rights and Freedoms, we're still protecting that association, or we're not violating those association rights? Is that what they're going to say?
Well, I've seen it reported that the minister has announced that they intend to take the position that the collective bargaining, the process of collective bargaining has in fact been respected and the requirements under the Charter in fact have been met. And so what we know is after the Fraser case, which rebooted the standard after BC Health Services, there were a couple of cases that the Ontario Court of Appeal had a chance to elaborate on what that standard may mean when thinking about what makes up meaningful dialogue that forms this process of collective bargaining that's required. And in a similar case, the Association of Justice Council, where there was federal wage restraint legislation imposed, the Association of Justice Council argued that that legislation that imposed a wage freeze in fact, was unconstitutional and a violation of freedom of association. And the Court of Appeal, looking at BC Health Services and the standards set out in Fraser, said, you know what? What's required here is the ability to have meaningful dialogue. And essentially what the Court of Appeal has interpreted the Fraser standard to mean is the opportunity for a trade union to make representations to the employer, and for the employer, the requirement for the employer to listen and take on board those representations and to consider them in good faith.
Okay, meaningful dialogue being the operative words here, right? So if you know where you have to land, in other words, if you know what the finished agreement is going to look like, can there be meaningful dialogue, particularly if the Minister of Finance is allowed to rip up whatever he doesn't like?
Well, I think that's a great question, and I think it's a bit difficult. I haven't been involved in any way in the collective bargaining negotiations that's taken place, so I don't have any insight into what's happened. And I think what this will essentially turn on is the question, when the legislation was imposed, did the parties have an opportunity to engage in the process of collective bargaining up to that point? So had the trade unions been in a position to make representations to the employer, and had the employer considered those representations in good faith? And if that took place prior to the enactment of the legislation, then in accordance with this standard articulated by the Ontario Court of Appeal, the unions face an uphill battle in arguing that this legislation is unconstitutional.
So, Faye, do we have a problem here in as much as the government would certainly say, yeah, we had lots of opportunity for meaningful dialogue and you unions got up and left the table?
I'd say two things in response to that. First of all, I think that there's a real issue about whether Fraser has rebooted the jurisprudence. I was involved in the BC Health Services case. I was counsel on the Fraser case. Fraser confirmed that the right to bargain collectively is protected. And I think part of the case will be about what does that mean, but I would disagree with the notion that it's been rebooted. And in this case, part of the claims are that the government, beginning in February of 2012, before the legislation was passed, already set an absolute firm mandate for what school boards could negotiate, and in those the provincial table trying to come to a voluntary framework set out exactly the bottom line that they've codified in Bill 115, and that there was no opportunity to actually bargain in those earlier stages because the government, rather than the school boards, was directing what could be on the table and what the outcome had to be.
Okay, so again, as we try to kind of understand or speculate where this is going to go before the courts, this whole notion of meaningful dialogue, there's going to be a good argument about that, isn't there?
Yes.
About whether you had it or whether they didn't have it. And the government thinks they had it and the unions think they didn't have it.
And I think that it'll come down to what evidence the parties have, but I think that it's not a clear-cut case for the government to say that that this is clearly meaningful dialogue. I think that there's the unions have a strong claim here.
Sonia, you wanted to add?
So, for example, in the Association of Justice Council case, the court was influenced by the fact that the parties had met, I think it was on 15 or 16 occasions, and met 5 times with the assistance of a mediator. So those sessions and those efforts in those sessions satisfied the process of collective bargaining that was required. And I agree with Faye that it, in fact, will turn on the evidence that both parties lead with respect to the collective bargaining sessions that took place. And in fact, the number of those sessions, what transpired, the proposals, and whether bargaining in good faith happened at those sessions.
But if the majority of the judges, and forgive me here, is this judges or a single judge, or who's considering this?
At the first level, it'll be a single judge at the Ontario Superior Court of Justice.
Okay, so if the single judge looks at this and says, you know what, 2D is operative, and you're messing with their freedom of association, case closed, is that it?
Probably not. Probably not. In fact, a number of these cases will, certainly this case will likely go to the Ontario Court of Appeal regardless of the result at the first instance. And maybe there may be leave sought to appeal to the Supreme Court of Canada as well.
Okay, so we're into a long road here, right? This is not going to be resolved by the next election or maybe the one even after that.
This is not going to be resolved immediately, and there's a whole range of other litigation that's going forward where, for example, the federal government, like I said, has also tried to impinge on the right to strike and collective bargaining.
Okay, let's get, should we bring the next section up here? Here's section 1 of the Charter, since we're giving everybody here a crash course in some operative sections of the Charter. Section 1 says the Canadian Charter of Rights and Freedoms guarantees the rights and freedoms set out in it, subject only to such reasonable limits prescribed by law as can be demonstrably justified in a free and democratic society. I don't know if that's a loophole big enough to drive a Mack truck through, but it's big enough to do some stuff with, right? I mean, you lawyers would acknowledge that there's something going on here that says, okay, even if your rights have been infringed upon, you don't have them absolutely positively. Is that fair to say? Okay.
And, well, what the government has to do, if the unions prove that there's a breach of freedom of association, then the government has an opportunity to justify that breach based on what's acceptable in a free and democratic society.
In other words, we're violating your rights, but there's a good reason why we're violating.
But there's a good reason, and they have to show that they have an objective that's pressing and substantial, that there's minimum impairment of those rights, and that any of the deleterious effects are outweighed by the benefits of it. And I think that what is critical here is the minimal impairment, that there is not minimal impairment. The extent of the incursions are so deep in terms of letting the government, by the cabinet, order the content of collective agreements, override them. The cabinet, without going back to the legislature, can prohibit the right to strike. There's no alternative dispute resolution mechanism in the event that the strike is prohibited. That is a very deep incursion. We've never seen anything like that.
But Sonia, I think I know part of what the government will say, which is we're going to save $2.8 billion for taxpayers across Ontario. So that is a reasonable limit on the association rights of the unions in question here, because we need to save $2.8 billion. Is the financial argument like that something that courts tend to be open to?
Well, it's interesting. My own personal view is that this case will either be won or lost on the Section 2D analysis. It'll be determined on whether or not it's in fact an infringement of the freedom of association rights, and it won't necessarily turn on Section 1. But if it is in fact found to be a breach of the freedom of association protection in the Charter, and it's necessary to go to Section 1, which is sort of considered the saving provision, if you will.
That's the argument you use when all the other ones you think you've lost on. We've still got Section 1.
Well, yeah, Section 1 certainly can save the day. Now, whether or not a financial argument will be accepted as fitting in within the threshold, the legal test that's created under Section 1, does remain to be seen, although it certainly will be the argument that the government will likely advance.
So, Faye, if the judge, in his or her wisdom, decides that, you know what, yes, your association rights have been infringed upon, the government is wrong, this law is unconstitutional, we're setting it aside, does the court have the right to impose a remedy or a punishment on the government, such as you're going to have to give them 2% a year for the next 2 years, or 3% a year for the next 2 years?
There could be financial consequences like that. That certainly is what flowed out of the finding in BC Health, that the legislation there was unconstitutional. What the government has tried to do in this case, in the legislation in Bill 115, they've put in provisions that purport to prohibit any remedy like that. And that's also part of the challenge, is that there are provisions in the legislation that try to restrict a court's capacity to review any action taken under the legislation, to prevent any cause of action, any legal claim from coming forward, and to prevent a remedy. And that in itself is a further thing that is considered a breach of freedom of association, a breach of security of the person, and fundamentally incompatible with the Constitution.
Okay, but you know, Dwight Duncan, the finance minister, was in that chair a few days ago, and he said, basically, I'm going to paraphrase, even if we lose the battle, we're going to win the war, because we have to save that money. So if we lose in court, we're firing 20,000 teachers and education workers in order to save that money.
And they kick the problem down the road while the litigation is going on. They're just kicking the problem down the road. But it's, the fact that there are financial consequences isn't something that gives you a right to automatically override the Charter. A lot of this case is about what's the quality of the democracy that we want to have. These are fundamental rights, and they only have meaning if we actually have access to them. They're not something that you just get when the economy's good.
Okay, we've got about a minute and a half left here, which allows me to ask each of you to look into your crystal balls and see how you think this is going to turn out. Sonia, do you have any clue as to how you think the court would decide on this?
Well, on the point of remedy that Faye was just mentioning, in BC Health Services, certain sections were declared unconstitutional. So that's likely if the government is unsuccessful, what will happen is certain sections of this legislation or the entire piece of legislation will be declared unconstitutional. So it will be sort of back to the drawing board,
Right.
if you will, on how to handle the issue.
Is that your prediction?
No. My prediction is, I think in the face of the recent Ontario Court of Appeal cases interpreting what we now know about the process of collective bargaining that's protected under the Charter from BC Health Services and Fraser, I do think the trade unions face an uphill battle if in fact they had an opportunity for a meaningful process of collective bargaining prior to the introduction of the legislation. If they had the opportunity to make representations to the government, and the government can prove that it considered those representations in good faith, then it is an uphill battle for a successful challenge.
Last 20 to you, Faye.
I think that the unions have a strong claim, and I think what's important for the public to take away from this is to look at the implications of this, like I said, for the quality of our democracy. Governments cannot treat charter rights as something that's inconvenient.
Even if the bottom line is hurting.
But there, you know, what choices? There are other choices government makes that puts them in that box, and those also have to come under scrutiny.
Gotcha. I want to thank both of you for helping us through this somewhat complicated but much clearer legal case now. Faye Faraday, the constitutional labor and human rights lawyer, and Sonia Regenbogen, partner at Heenan Blakey LLP. Thanks to you both.
Support Ontario's public television. Donate at tvo.org.